Why is Schrems II crucial for cross-border data? Imagine trying to send personal information from one country to another, but suddenly finding the rules have changed. That's what happened with the Schrems II ruling. It's a key decision that shook up how companies transfer data across borders. If you work with data from the European Economic Area, or EEA, this ruling is a game changer. It affects how organizations use standard contractual clauses to move data outside the EU. Before Schrems II, many companies relied on these contractual agreements to keep data safe when crossing borders. But the ruling made it clear that these clauses are not enough on their own. Companies now have to check if the country receiving the data offers enough protection. If the laws in that country allow government agencies to access data easily, then the transfer might not be legal. This means organizations must do detailed assessments of the legal environment in the destination country. They need to look at surveillance laws and government access rules. If the protection isn't similar to what the EU guarantees under the General Data Protection Regulation, or GDPR, then companies must take extra steps. These could include adding more safeguards or stopping the transfer altogether. Schrems II also emphasizes the importance of data sovereignty. This means data should be protected by the laws of the country where it originates. When data moves to a country with weaker privacy rules, it raises concerns about privacy rights and government surveillance. This makes organizations more cautious about where they send data and how they protect it. For companies involved in artificial intelligence and technology, this ruling is especially important. AI systems depend on large amounts of data from different countries. If data transfers are restricted or requiring extra measures, AI developers need to rethink how they store and process data. They might need to localize data within the EU or use advanced privacy technologies to stay compliant. The ruling also has serious consequences if organizations don't follow the rules. Noncompliance can lead to hefty fines, sometimes up to 4% of a company's global turnover. It can also mean being ordered to stop data transfers altogether. For businesses that handle personal data across borders, this means they have to be very careful. They need clear, strict procedures to ensure they meet GDPR requirements when transferring data outside the EU. In the world of data privacy and compliance, Schrems II has made organizations more aware of the legal risks involved in cross-border data flows. It pushes companies to be more transparent and diligent about how they transfer and protect data. For those working with artificial intelligence and technology, this ruling encourages innovation in privacy-preserving methods. It's about finding new ways to share data securely without risking privacy violations. In short, Schrems II is a turning point because it demands stronger safeguards for international data transfers. It makes organizations think carefully about where their data goes and how it's protected. This impacts not just legal compliance but also how AI and tech companies design their systems. The goal is to keep data safe, respect privacy rights, and follow the law, no matter where the data travels.